summarize, Your Honor, about rising and discussing this, especially because of my high respect to the presiding officer and to a seeming consensus of the Senate. But I do not want this to be a precedent. I do not want either side to ask for a subpoena later on, and then we will be ruling based on our interpretation of the law without considering, Your Honor, that in fact the prosecution or the defense is in fact entitled to that subpoena, Your Honor. So I'd just like to put this on the record, Your Honor. Under the rules, we can ask for a vote for the Senate. I do not know if the prosecution will be filing anything, because if they will be filing anything, then I will not ask for a vote at this point in time, and we can decide this later on. No? Many have said that the allegations can be proved by other means, but as I said, no, whether or not the family should be called is not my call. I have my personal stand and belief on that issue, but it is irrelevant at this time, and I should not even say what my personal belief is about calling the family. But whether or not they should be granted a subpoena, may I just summarize, Your Honor? I agree to the ruling as far as the Chief Justice, but I disagree as far as the wife, the children, the son-in-law, and the document sought to be subpoenaed, Your Honor.
Before I posit the question, I would like to state for the record that the Chair has no intention of depriving or shackling the prosecution from obtaining evidence to prove their case. In fact, I have signed the request for subpoena duces tecum against the respective registers of deeds of the various cities where disclaimed real estate properties are located, including a subpoena duces tecum for them to produce the certificates of the transfer certificates of titles and the condominium certificate of titles, if any. And I think the prosecution has all the means to obtain the evidence properly if they apply the rules of evidence. By the way, these subpoenas were released by this chair early this morning. Now, if the purpose of the manifestation is for the gentleman from Taguig to appeal the ruling of the chairs to the Senate, please make it in the form of a motion properly so that it can be disposed of. The gentleman from Pampanga.
Thank you. With the permission of Senator Cayetano, Mr. President, just a point of inquiry. I am sort of confused because earlier the prosecution manifested that they are to file or submit a motion for reconsideration. But after the Senate President explained the position or the ruling, the prosecutions made a manifestation that they are submitting to the ruling of the chair. So do we take it to mean, therefore, that they have withdrawn the earlier manifestation of submitting a motion for reconsideration and are therefore submitting to the ruling of the chair? Just a clarification, because there were two manifestations, Mr. President.
They have already, according to the record, they have already submitted to the ruling of the chair. But a member of the Senate has made a remark in the form of a manifestation. That's why I'm asking him if he's appealing the ruling of the chair to the body.
Yes, Your Honor, with all due respect, and I agree, Mr. Presiding Officer, I did not make any imputation that the presiding officer or anyone in the Senate is stopping the prosecution or the defense from proving their case. My point, Your Honor, is that I just want to follow the law and in accordance with my interpretation, Your Honor, that if they ask for a subpoena and under the law they should be granted a subpoena, that is the reason I stand and ask for a reconsideration of your or for the body to vote on the ruling of the chair, Your Honor.
You know, my knowledge of evidence is that the adverse party in a civil case can be summoned by the other party to testify in favor of the requesting party, but this is not a civil case. This is in the nature of a criminal case. So that is the very basic reason why the ruling of the chair was made.
Well, Your Honor, if we had a pre-trial, then the exact nature of the impeachment case, whether it is in the nature or simply akin to a criminal case, could have been thoroughly discussed, Your
remind
Honor.
the gentleman that we do not have a rule on pre-trial
Yes, Your Honor.
according to the rules of impeachment.
I was simply explaining, Your Honor, that there is a very rich, there is a wide amount and a rich amount of discussion on whether or not an impeachment case is in fact criminal in nature, civil, administrative, and it has been described as many as being sui generis or a class by its own, being akin to a criminal case, but having a different process or procedure, Your Honor. And while I agree, Your Honor, that we will be following the criminal rules of procedure, Your Honor, as I said in the arguments I made a while ago, that at the time that they are called and the evidence is offered, that is the time that the witnesses called can claim the privilege or can claim the disqualification. But at the time that they are asked to be compulsory brought to the Senate, that is the right of the prosecution, and that is the interpretation, Your Honor, of this representation, especially, Your Honor, to the son-in-law, which I feel is very clear, and there is a Supreme Court case that states that son-in-law, it should be a direct ascendant or descendant. Pero kung asawa po ng anak, hindi po to covered ng privilege, ng filial privilege, Your Honor.
May I remind the gentleman that under the rules of this court, every member of the Senate has only 2 minutes to speak.
Yes, Your Honor.
We are tolerant, but I would like to read for the information of the gentleman that the grounds of impeachment are culpable violation of the Constitution, treason is a crime, bribery is a crime, graft and corruption is a crime, and other high crimes. And that is why this chair considers this proceeding akin to a criminal case.
Yes, Your Honor, I do not disagree with that, Your Honor. But I disagree with the ruling, and I do not want it to be a precedent, Your Honor. That's why I brought it up before some members in our discussions about whether or not a subpoena can be issued, and I'm asking that the Senate decide whether or not they should be issued a subpoena. And, Your Honor, may I please point out, there is a difference as to the plea to the issuance of a subpoena to the CJ himself, the wife, the child, the children, and the son-in-law, Your Honor.
We note the opinion of the gentleman, and may I request him to please allow the proceedings to go on.
Yes, Your Honor. I'm not delaying the procedure. I'm simply making the motion to amend the ruling, wherein the ruling as far as the CJ will stand, but as the ruling to the children and to the son-in-law and the wife, that the subpoena be issued by the Senate, Your Honor.
Are you appealing the ruling of the chair to the body?
Yes, Your Honor.
Well, then I'll put it to a vote. We are the majority floor leader.
If the body is willing to take a vote, we are ready to take a vote, Mr. President. But there is a suggestion that a recess be called by one of the members.
Session suspended for 1 minute.